Have a seat, please. Ready for our next case, Julie Murray versus Chester Murray.
Morning, Your Honors.
Morning, counsel.
May it please the Court, Michael Donnelly on behalf of the appellant Julie Murray. We're here on a case that was tried before the Circuit Court in Brevard County.
Now, you're just arguing about custody now, given our order, right?
Correct, Your Honor. Our argument today is limited to the issue of custody. Unfortunately, there was no trial transcript at the...
That's pretty much the death knell, Mr. Donnelly, to be honest with you.
I understand, Your Honor.
Got a real uphill battle on a factual determination without a record.
We worked as hard as we could based on the language that was in the final judgment, and thankfully, although it seems to be a slightly irregular final judgment, it is rather comprehensive and longer than usual with several of the factual findings that the trial court did.
Well, you got a list of factors, and you're not saying that he didn't touch on all the factors, right?
No, Your Honor. Our argument is that there wasn't a meaningful analysis of the factors that were mentioned, or that the evidence that was...
Well, the factors that you identified in your brief, you won on, right? Domestic violence, he found in favor of your client, and he found that that factor weighed. I think that was the one that he said heavily weighed in favor of your client, right? What was the other factor you mentioned? Your
Honor, the court weighed several factors, on behalf of both parties in reference to Chapter 6113 in trying to make a determination as to which parent should be awarded custody. Specifically,
what was the other factor that he didn't give a sufficient enough analysis to?
Well, there was, of course, 6113 subsection 3L regarding the domestic violence, but there was also...
But you won on that one. So what difference if he didn't? If his analysis was shallow and you prevailed on that factor, what difference does it make whether it was shallow? Are you saying that the father should have prevailed on that, or?
Well, no, Your Honor. We're arguing that based on
he didn't give it enough weight, is what you're arguing.
The weight of all those factors, correct, Your Honor, and the totality of the circumstances based on all the different factors that were considered, right. We would argue caused...
Did the legislature say which factor gets the most weight?
Well, Your Honor, the legislature did not give a specific...
Do we do that, or does the trial judge do that?
I think the trial judge needs to do that, Your Honor, based on the various factors in A through M of 6113, and they have to, all other factors being equal, they should look at certain elements more closely. However, none of the factors were really equal in this case, and our main argument is the analysis of the different factors in 6113 weighed heavily in favor of the mother on several issues, and that analysis by the trial court or the application of the record evidence did not comport with what 6113 would dictate as far as custody determination.
Which factor do you think is the most important one, Mr. Donnelly?
I think the most important factor as it relates to the appellee and...
No, in a vacuum.
In a vacuum?
The abstract, when a judge is looking at all these factors that the legislature is enumerating and trying to decide which parent should get custody, which one do you think is the most important factor?
It seems that based on the case law, in a vacuum, the courts will weigh heavily in favor of of Section A, the parent more likely to allow frequent and continuing contact.
It's the one that the legislature listed first, right?
Right.
And it would seem to be, just be logical that that's a pretty darn important factor, right?
I would agree that is a very important factor, as well as J, which...
How did the judge come out on that one?
The trial court ruled that based on 3A, that factor weighed more in favor of the father.
Didn't he say heavily in favor of the father?
I believe he did, Your Honor.
And you're not really in a position to attack his finding there because you don't have a record, right? The transcript.
Correct. Our main issue with the ruling was that although he did make a determination that Section 3A did heavily weigh in favor of the father, there were several factors which weighed heavily in favor.
Well, if the trial judge finds that Factor A weighs heavily in favor of the father, and he finds that every other factor weighs in favor of the mother, is he or she bound to make a custody determination that favors the mother, or is it still up to the trial judge to decide which is the most important factor under the circumstances of the particular case?
I agree that the court does need to determine which is the most important factor. I would argue, though, that if the court found that all other factors weighed heavily in favor of the mother, then even if A did not, the court would be bound by the weight of those other factors to make a custody determination in favor of the mother in this case. Specifically...
Well, that might be true if we were able to read a transcript and make a determination as to whether there was any substantial basis for those conclusions. Don't you agree?
I agree. However, in the final judgment, like I stated earlier, Your Honor, they do make the effort to actually reference several points that were brought up in trial, several bits of evidence, one being allegations of possible child abuse by the father. In fact, the court states that there was a...
Well, it's quite clear that the judge considered that, right?
Yes, and our argument is that even though the court did consider all these different factors, there was child abuse or allegations that there may have been child abuse, there was confirmed allegations of domestic violence by the appellee on the appellant, and there was a permanent injunction.
And the judge considered that?
Then the judge considered that, and the judge, I think importantly here, did consider the marijuana use by the father. And we argue that all those factors taken together...
He said, with respect to the marijuana use, father said he's quit, but I don't really believe it.
Right. And
he still ruled as he did.
Correct. And that's what we don't understand the logic and the justification for the court's ruling after stating that throughout the entire marriage the father used marijuana, in fact, in close proximity to the children.
Would you agree with me that our standard of review is abuse of discretion?
Yes, Your Honor, and I would point the court to Kanakeris where they describe what an abuse of discretion is.
What did the Supreme Court say in Kanakeris?
Well, Your Honor, in the definition of abuse of discretion, the court has stated that when the judicial action is arbitrary, fanciful, or unreasonable, and that constitutes an abuse of discretion when no reasonable man would have ruled in that way.
No reasonable man would rule in that way.
And we would argue that based on all these different factors that were considered by the circuit court, that it would not have been reasonable for any trial court to make this ruling, just based on, again, domestic violence, allegations of possible child abuse, drug abuse in the close proximity.
So you're urging us, Mr. Donadell, just think about this for a minute, all right? We're going to write an opinion that says that as a matter of law, even though we didn't hear any of the evidence, and even though we can't see any of the evidence, as a matter of law, if the judge finds that factors, X, Y, and Z favor the wife, even though the judge finds that factors A, B, C, D, and 4 or 5 other factors favor the husband, and as a matter of law, the judge is obligated to make a finding that primary custody should be awarded to the wife. That's what you want us to do, right?
Well, Your Honor, I think what...
You want us to revert, you want us to essentially you're not asking us to remand it for a new trial, right?
No, Your Honor, but I do think the case law would dictate that if the court were not to reverse based on the argument on appeal, then they would be obligated to remand to the circuit court for an additional evidentiary hearing on issues that were not sufficiently supported in the record.
Well, we do that when the judge doesn't say anything about one of the factors, where his order, omits any discussion about a factor that was a disputed factor, in the evidence. And we're concerned that he might have forgotten about that factor or not. We don't know whether. But here the judge went down, all the factors that were at issue and made rulings on each one. Do you have a case that says that we have the authority to essentially, reweigh the factors, even though we didn't even get to hear the evidence and didn't even get to read the evidence?
Well, I understand that, Your Honor, and frankly, I'm sure the court would agree that there's probably been, to a large extent, a lack of case law which states that a parent who uses or abuses an illegal drug in close proximity of their children should not necessarily be awarded primary residential custody of their children, and that's probably not in the best interest of the children. There's not a lot of cases that have addressed that, and I think the reason for that is it's simply a matter of common sense. I don't see, and I can't fathom how a trial court would award two small children to be in the primary custody of a parent who is on an ongoing basis using an illegal drug in their close proximity.
Well, sometimes the trial judge is given the choice of a lesser of two evils. He didn't have a lot of nice things to say about your client either, and of particular concern to him was the fact that your client might alienate the relationship or alienate the father and poison the children so that they don't have a loving relationship with their father, which concerns a lot of trial judges.
That's certainly a concern, Your Honor, and that goes back to the analysis of all the factors. While factor A may carry the most weight and certainly require deference, and it seems to be the legislature's intent in putting it first, there's at least four factors that follow it which heavily favor the mother. And we believe that, again, once the court reviews the final judgment, it's either been just mentioned in passing or there's been no analysis of those factors in the context of 6113 whatsoever to offset 3A. And I think if you look at the totality of all the factors that are written clearly in the final judgment, there are serious concerns here that would not comport with the court's decision to award custody of the father. Specifically, Section 3D, although the court references the fact that the marital home is going to be awarded to the father, and for reasons set forth in a different part of the final judgment that we're not here to argue about today, but the court indicates that based on maintaining continuity in a stable environment and a satisfactory environment, the father should be awarded custody of the children in the marital home. And our argument there is that analysis is entirely incorrect, because how is the home a satisfactory environment when in the very next paragraph of the final judgment, I believe it's 6F, which was 6D is where the court indicates that the satisfactory environment is the marital home, but in 6F states that the father has been continuing to use marijuana on a daily basis and in the close proximity of the children.
Well, it doesn't say on a daily basis.
I am sorry, Your Honor. That is 6F, the father has used marijuana while the children are home and in the close proximity of them. You're correct.
Yeah, he also points out that the mother used marijuana as well.
Earlier in the relationship, yes, Your Honor, and not at the point where the dissolution was filed. But it goes on from there, and it's not just Section 3D, it's Section 3F, the moral fitness, I think, of the fathers seriously put into question by the drug use. And then, again, to correlate 3D and the court's misapplication of 6113 there, in 3J, the court indicates that the father would have the willingness and ability to facilitate and encourage a continuing parent-child relationship, yet he states that the father there too would have a difficulty in that regard because of his self-righteous attitude. That's in paragraph 6J of the final judgment. So there's two contradictions in two of the main arguments that the court makes that the father should be awarded custody. And to put the icing on the cake, so to speak, in Section 11, there's clearly evidence of both domestic violence and some allegations of child abuse or excessive corporal punishment, to say the least. And the court, it's not in the final judgment. We're not here to argue the facts today, but these are very young children. They're both daughters. At the time of this, I believe they were 3 and 5 years old, so we would argue that there really wasn't any reason for any corporal punishment of young daughters. But in the totality, to look at all those factors, and then to say because she wasn't as eager to facilitate continuing contact with the father.
Well, it's not that she wasn't eager. It says that she has a great deal of animosity towards the father, and she's consistently attempted to block the father's visitation and contact with the children. And it gives an example that she insisted that a third party supervise the visitation exchange, but rejected all 18 individuals suggested by the father And at the same time, she failed to suggest anyone that would be acceptable to her to supervise the exchange. That's a little bit different than how you characterize it.
And again, Your Honor, we can't, we're not here to argue the facts, nor do we have a record to reference.
You can't argue the facts. Yeah.
Right. So I can't state with certainty, and of course I wasn't the trial attorney, whether or not that is in fact the case. I'd have to, defer to the correctness of the final judgment in regard to how many folks she says she declined to have supervise the children, although I would point the court to the fact that a separate circuit court entered a permanent injunction against the father because of violence by the mother after they held a hearing on it. And our argument is that is the main reason why she had a reluctance and a fear, and that she was possibly perceived as being difficult to work with the father on visitation. And that if that wasn't a good reason, then you can look to all the other factors that we've talked about earlier in addition to those. But I would argue that the domestic violence is certainly one of the more serious allegations. The court in its final judgment references really four main things that relate to two parts of 6113. Her reluctance to facilitate contact with the father while the children are in her care, the alleged abandonment of the children by the appellant for a brief period of time. I suppose if you had to categorize those, they would fall under 6113, 3D, and 3J. And then the court's decision to award the marital home to the father, and that the children should have the continuity to remain in the home. That is, again, Section D. And then the fourth reason that they note is that she doesn't care for the father. So again, those really, and I don't see how they would really relate to any than those two sections of 6113. But if you read all those sections of 6113, you see at least four, possibly five different things that the father's behavior does not comport with. And that would be not only D and J, but of course F for the moral fitness of the father based on his drug use, and L, which is the fact that there was domestic violence and a permanent injunction entered. It just doesn't seem reasonable. It doesn't seem to comport with the logic and justification that's required for a trial court to apply in reaching its decision. And we feel that based on that, the court's has abused its discretion. Are there any questions further?
Thank you, counsel.
Thank you, Your Honor.